All right, hello everyone, and welcome to this live stream session. Thank you so much for being here today. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you've found my live session where we talk about employment law and workplace rights, and I help solve problems and answer questions and tell you what you need to know about employment law. Again, I'm Lior Samfiru, the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. My firm helps individuals with respect to employment and disability issue across Ontario, BC, and Alberta. And if you're in one of those places, you can ask the question right now. Let's make sure you get some answers, you get some knowledge, you get some help and direction. Of course, this is just one way to get help, but man, is it a good way. I'm live. I want you to keep me busy. Ask as many questions as you can, as many questions as possible. There's no bad questions. There's really only answers and solutions. And every question I get today in this session, I will answer. But of course, this is only a 30-minute session. As I said, if you want to connect with me and my team off social media, off live stream, it's so easy to do. You just go to employmentlawyer.ca. See that address over there. Employmentlawyer.ca is going to give you the phone number. It's going to give you the email address. It's going to give you the fax number if you still use a fax. It's going to give you all the information that you need so we can connect. And it's also going to allow you to read a lot more about employment law and the rights that you have. Remember, this is about the rights that you have. You have employment law rights. You have workplace rights. If you don't believe that you do, it's probably because you just don't know what those rights are. No big deal. On this session right now, you can ask the question to find out what your rights are, to ask what to do if you lost your job and you don't think it's right, if you've been discriminated against, if you have not been accommodated, if your boss is threatening to change your job or forcing you to resign. I think you get the idea. If you're dealing with a workplace issue, if you're dealing with a bad boss, bad company, loss of a job, anything to do with your job, man, oh man, what a great opportunity you have right now to ask a question, get some answers, get some help. I see questions have already come in. I'm going to start answering them right now, but please ask your question. You got lots of time, so no need to rush. You can sip your coffee and type in the question, and I'll see it and I'll read it and I'll answer it. So again, I'm Lior Samfiru, the employment lawyer, live with you right now to answer your questions. So I think we should go ahead and do what we came here to do, which is to answer questions. First one today, right off the bat, is Pursuit of Happiness, who says, quick HRTO case question, accommodation request on November 14th at 3:38, termination notice dated November 17th, metadata shows letter created that day at 1:15 after morning discussions. Except you, okay, let's see. Employer claims decision November 13th, call said shortage of work. Record of employment says shortage of work. So, okay, obviously I want to see the documents myself. I want to understand exactly what happened. Obviously the timing here doesn't look good for the company, but the devil's in the details, right? We want to understand what it is that they've done. And by the way, you may have only asked for accommodation on a certain date, but they may have already known before that that could be coming up. Maybe you've had some informal discussions, or they knew you were dealing with the medical condition. So even if the decision happened before you made the formal request, it doesn't mean that it's not a human rights violation. If they let you go because they didn't want to accommodate you, obviously that's illegal. They have to accommodate you. They can't avoid that by saying, oh, no, it's a restructuring. So we really have to understand the timing of this and what they knew or what they didn't know. But there's something else here. Even if it is shortage of work, it has nothing to do with anything, you're going to be owed severance. So we need to talk about what that severance is. We need to make sure that you get what you're owed. So there's a lot of things for us to discuss that we can't obviously do here on live stream. So Pursuit of Happiness, what do you do now? Well, very easy. You connect with me through employmentlawyer.ca. Again, employmentlawyer.ca, address is right there. And let's have that chat. Let me see the relevant documents, the letters, and I'll make sure that you get everything that you're owed, and they're not allowed to get away with something that's not legal. So thank you for that Pursuit of Happiness. You know how to reach me, employmentlawyer.ca. And if you're just joining us now for the first time, thank you. Welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. and I'm here to help you get answers to your employment law questions. So please ask it right now. I'm right here. Make sure you ask. All right, let's continue. Next question of the day comes to us from YouTube, and this is from Samfiru. Thanks. Okay. If an employee had no disciplinary history and is getting negative job references from a former employer, can you give a cease and desist notice? Is this defamation? What are my options? Thank you kindly. So if your employer is lying, if your former employer is lying when they give a reference, for example, if they say things that are for sure false, they say, yeah, you were late every day, and they say, and you were not, and we can show that you were not, then that is defamation, and that's illegal, and there could be significant consequences. On the other hand, if he says, listen, I just wasn't happy with their performance, how do you prove that that's false? You can't prove that he was or was not happy, right? So we need to know what he is saying to be able to say that that's defamation. Your employer cannot, former employer, any employer cannot say false, bad things about you to publicize that. That's why we have defamation laws. And if because of that you're not getting a job, that's a huge problem. And that's illegal, and you can take legal action. But of course, you have to show that what your former employer is saying is in fact false. Not just an opinion, but false. So an opinion, not much you could do about it. If they're flat out lying, defamation, illegal, significant consequences. So if you want to talk about this, let's connect. You can reach me, of course, through employmentlawyer.ca right there. And let's have a chat. I want to understand what your former employer is saying, to who is there saying that, how do we know, and find out more about the circumstances of the job that you had previously. So thank you for that. Great question. By the way, you as well. You can ask your question right now as well. I see some questions have come in. Let's make sure that we answer them. And let's make sure that when you turn off your computer or shut off your live stream today, you know more than you did before you joined us, that you feel better about your legal rights. That's the whole point about this. It can be very stressful to deal with a workplace issue and not to know what your rights are, not to know what to do. Well, we try to take away some of that stress by arming you with knowledge, by arming you with information and with answers. So don't be bashful. Going on the World Wide Web and trying to figure out stuff on your own, man, that's not a good idea. I'm right here. Ask the question. You have the box on your screen. Type it, hit enter. It's going to pop up on my screen, and I'll answer it. I'm Lior Samfiru, the employment lawyer. Let's continue answering more questions. Hannah J, next question. My work has been cutting my hours with little to no explanation. Is this allowed? What should I do? So generally speaking, remember the rule. Your employer is not allowed to make significant changes to your terms of employment. So if they're cutting hours, obviously that's a big deal, because now you're getting paid less. And that's whether they have a good reason or no reason, frankly, it doesn't matter. They simply can't do that. So what happens if your employer does that? That may give you the right to consider it a constructive dismissal. A constructive dismissal happens when your employer makes changes that are not allowed to be made, and you're then able to consider that as a termination and leave with severance. So that's what you have potentially the option to do here. Now, why would that be better than just continuing to work? If you accept these changes, so let's say they reduce your hours and you accept, by doing that, you've now given them the right to do it again and again and again. And when they do it again in the future, you won't be able to say constructive dismissal because you let it happen back then the first time. So please be smart. Don't let that happen. If your employer is changing your hours, your pay structure, your work location, demoting you, if your employer is doing these things, it could easily be a constructive dismissal, which gives you rights. So what I want you to do, Hannah, I want you to connect with me off air. I want to understand how many hours they've cut, over what period of time, and let me help you make sure that we enforce your rights. If you don't enforce your rights, you may lose your rights. You don't want that to happen, right? So Hannah, you can connect with me again, employmentlawyer.ca. Again, employmentlawyer.ca, the way to do that. I'm right here and wanting to help you make sure that you get those answers. Thank you. Great questions, by the way. If you're now joining us for the first time, I'm employment lawyer Lior Samfiru with Samfiru, Tumarkin, LLP, and our firm across Ontario, BC, and Alberta. If you have an employment law question, this is the time. this is the place, this is the opportunity to get answers. So please take advantage of it. Don't kick yourself later saying, man, I wish I would have asked the question. Just ask it. Easy. I'll give you the answer. It's going to be no problem. I want you to keep me busy right until the end of the session. I want to, when I shut off my webcam, I want to be tired and needing a drink of water because I've answered so many questions. So ask your question as well. All right, let's continue right now here. And I see here a very long one. Let me see if I can get through it. Usually try to make your question a bit shorter so I can get through it properly. Hari, I'm a foreign worker employed in Canada. I've worked with this company for 5 years, initially in Singapore and then transferred here, and my work permit ends in June. If they lay me off or terminate me, whether with cause or without cause, am I eligible for severance? And does my temporary resident status put me at a disadvantage? Given my 5 years, can I expect severance beyond the 4 weeks they're offering? Finally, I'm requesting to a relocation back to Singapore, but they've been unclear. If they delay and simply let me work, my work permit expire, saying they won't renew, can they end my employment that way? Is that something my employer can do legally? So if it's up to them to renew your work permit and they decide not to, they can, but they don't, then yes, they owe you severance. If your employment, if your work permit expires, but it's nothing to do with them, then they don't owe you severance because it's really nothing they can do about it. If they have to renew your work permit, but they choose not to, you're going to be owed severance. And yes, your severance is going to be based on your 5 years, including the time you had at Singapore. So again, I don't know your age or the job you're doing, but you're probably going to be owed at least 6 months of severance and potentially much more than 6 months of severance. So again, it really comes down to, can they renew your work permit, but they're choosing not to? If they can renew it, but they're choosing not to, absolutely, then that triggers severance obligations. If it's kind of your problem that the work permit expires, but there's nothing they can do about it, then they're not going to have to pay severance because it's not their fault you can't work anymore. I hope that makes sense, Hari. If you're losing your job, connect with me, okay? As soon as possible. Don't wait. As soon as you know you're losing your job, connect with me. The address is right here, employmentlawyer.ca, to connect, to get help, to make sure that you actually get some answers and solutions. So please, employmentlawyer.ca, don't sit on this. You know, your rights are not going to wait for you. So connect with me through employmentlawyer.ca. Now, I was talking with Harry here about severance, and I was telling him, you know, I need some information, but he could be owed 6 months or more severance. How does Harry, and how do you find out how much severance you're owed? It's so very easy to do. All you do is you go to pocketemploymentlawyer.ca and you use our severance calculator. We created a severance calculator. Again, you can find that at pocketemploymentlawyer.ca. It's free. It's anonymous, no names, no phone numbers, no company names, no email addresses. You just answer some questions from a drop-down menu, and it's going to calculate for you how much severance you're owed. So you may not know, hey, do I get a month severance, 6 months, 18 months? How much severance? Again, pocketemploymentlawyer.ca to use that severance calculator. Nearly 3 million Canadians have used it already. Please check it out. It works well, and you may be shocked, actually, by how much severance the law provides for you. So many people think that if they lose their job, they get a week per year of service, maybe 2 weeks per year of service. Wrong. Both those things, completely wrong. It's a heck of a lot more. You'll be shocked. You may look at it and say, wait a second, are you telling me I'm owed 16 months severance? Absolutely. So again, pocketemploymentlawyer.ca, use the severance calculator. Definitely, if you've lost your job, first place you go to. If you're thinking or worried about losing your job, you go there right away. Or maybe you're just curious. Hey, I don't know, what would I be owed if they ever let me go? Again, go to pocketemploymentlawyer.ca, severance calculator, right there. Check it out for yourself. But right now, I'm still here live with you answering questions. Let's make sure that we get some more answers to you. Ask your questions. Don't be bashful. I'm still here, not going anywhere. So ask your question. Next question from Jamie. My employer has asked me to come back to office. I've been working remotely for 2 years. Is this allowed? So generally speaking, unless when you went remote, you agreed to come back whenever they ask you to, unless you sign something that says if they ever ask you to come back, they don't have a right to ask you to come back to work. Remember what I was saying earlier. Your employer doesn't have a right to make significant changes to terms of employment. Well, this is a significant change. If you're working remotely and now they want you to stop working remotely and come into the office, well, that's a significant change, which means they're not allowed to do that. So what can you do? You can do it, of course, but you can also say, no, I'm not doing it. If you say no, one of two things will happen. Either they'll back off and say, okay, fine, just continue working remotely, or they will let you go. Now, they're allowed to let you go as long as severance is paid. Remember, an employer can let someone go pretty much for any reason as long as severance is paid. So they can let you go, but they would have to pay your full severance. What they can't do is let you go without severance. What they can't do is say you've resigned. None of that is possible. So ultimately, those are the rights, those are the options. If you want to choose the right one for you, let's connect. Let's make sure that we've had that private discussion, and I'll help you. But that's been a question I've been getting very often over the past year or so. What do I do if my employer is telling me to stop working remotely? Well, you don't have to. That's a term of employment. Unless you signed something back when you started working remotely that says, if we ever call you back, you agree to come back. Unless you sign something like that, they don't have a right to do that. Hopefully that makes sense. You can connect with me through employmentlawyer.ca, and I'll help you. By the way, if you're just joining us now for the last 15 minutes or so, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, answering your questions live. I see more questions have come in. Ask yours, please. You still have time. If you ask a question right now, I promise you will get an answer. Just like Brandon has our next question. I was working somewhere for 3+ years. Recently, my boss and I haven't been getting along. I feel like I'm being micromanaged and he makes rude comments to me disguised as jokes. What should I do? So what you're describing here is a form of harassment. Being treated improperly, being spoken to rudely, being disrespected, it's a form of harassment. So the best thing to do with harassment is, if possible, to tell someone above him, the owner, the HR manager, the director, whoever the right person is in your company, to let them know in writing what's happening, okay? Once you do that, they have to, by law, they're legally required to take it seriously, to look into it, investigate, and then to fix that problem, okay? But you have to do it in writing so that they can't say you didn't tell us. In most cases, once you do that, it gets resolved. They speak to the person or they deal with them differently, and the issue goes away. If they don't deal with it, or if it doesn't go away, or if there's no one to talk to because the owner of the company is your boss, then you and I talk. We could potentially get you out of there. This could be a constructive dismissal by being mistreated. Let's talk about how do we prove that, because your boss is not going to admit this, right? So let's talk about maybe recording it, maybe creating a different record. So you can connect with me through employmentlawyer.ca. If it is possible, I want you to file that complaint with HR or the right person in writing. Otherwise, I'm still here. You can even ask a follow-up question, and you can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic. Great questions today, guys. You guys are awesome. So let's continue. Next question comes to us from Reddit, and this is from Alexei. My boss regularly asks me to respond to emails and take calls after hours without extra pay. Do I have to do this? The answer is no. You don't have to do this, and we have laws protecting you from not having to do work for free and after hours. You don't have to do this. Now, there's a practical reality, and I'm going to be very honest with you, like I always am. You cannot be punished for saying I'm not going to do that, okay? You cannot be. But here's what could happen. So let's say the next time the company is deciding who to promote, could the company say, well, I'm not going to promote Alexei, I'm going to promote this other person because the other person answers their emails after hours? That would be wrong for the employer to do. But if they did that, we would never know. And so that's always a kind of a consequence that could happen. But can you be actually punished? No. If you're working, you should be paid. And if you're off hours, you shouldn't be bothered, okay? When you're off work, you should be off work. So hopefully that makes sense. If you want to chat about it more, you can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic. Pursuit of happiness. I think I've already answered your question, so I told you what to do. Let's see. By the way, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, answering questions right now. I see some questions here. I'm going to continue answering them right now. Let's see. Rogan Hemp. Is an employer allowed to ask for an update to your medical status to continue providing working accommodation? Yes, they're allowed to, as long as it's reasonable. What they can't say is, I need you to give me an update every 3 days. That's unreasonable. But can they say, well, we've been accommodating you for the last 3 months. We need an update to see what your doctor says. Do you still need the accommodation? Has it changed? Do we know for how long? Yes, it's reasonable to ask for that, and you should provide that. The other thing your doctor can say, I will provide an update as soon as we have one. So in other words, the doctor could be telling them is that things are going to be status quo until I say otherwise. But again, it's not an unreasonable request to provide an update. And if your employer refuses to accommodate you, if they say, no, this is too much, let's talk. Because in most cases, your employer has to accommodate. It's a very high bar that they have to be able to say, no, we're not going to accommodate. So please reach out to me if there's any problems, employmentlawyer.ca. Happy to connect and talk privately. All right, next question from William. My employer changed my commission structure, and now I'm making significantly less. Can they do that without my agreement? So we were talking about that earlier. No, your employer is not allowed to make significant changes to terms of employment. So that means that if they take away your commission or change it so now you're making less money, well, that's a pay cut. And if it's a pay cut, unless it's a very minor pay cut, if it's a pay cut, that easily could be a constructive dismissal. Our pay, of course, is a very important term of employment. And if we used to make a certain amount of money, and now because of what the company did, because of their changes, we're making less, we may be able to say constructive dismissal. No, I'm not accepting that. And of course, if you accept it and continue working, you've given them the right to do it again. And next year, when they change it again and you make even less money, and the year after that, and the year after that, you're done. You're stuck. You can't do anything about it. So you have to stand up for those rights. So William, let's connect, of course, employmentlawyer.ca. If you know these changes are happening, we want to act on this now, not later. Okay. So again, connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. All right. Next question. Again, I'm Lior Samfiru. Yeah, the employment lawyer. My company says I'm an independent contractor, but they tell me when to come into work. Should I actually be classified as an employee? Well, you haven't given me much information there, but here's the thing. If you have a job, if you go to work, you come back, you go back the next day to do the job, you only work for one company, you're an employee, and it doesn't matter what the company says that you are. If you look like an employee and you act like an employee, you are an employee, not a contractor. So that's what we call a misclassification. So very important to understand that if you've been misclassified, but you really are an employee, then you have the rights of an employee, the right to get overtime and vacation pay and overtime pay, and the right to get severance, of course, if you lose your job. And by the way, I mentioned the severance calculator, right? But we also have a tool that allows you to find out if you're a contractor or an employee. Again, all you do is you go to pocketemploymentlawyer.ca and you click on the contractor tool and you answer some questions, and it's going to tell you if you're an employee or an independent contractor. It's free and anonymous, so please let's chat. All right. Next question today is from Alicia. My company is restructuring while I am off on a medical leave for surgery. I think I'm losing my job after 6 years with them. How do I navigate this? What should I do when they send me my severance? Well, let me start with the last part. What should you do? Very easy. You contact me. Easy. Okay, we'll look at it together. We'll make sure that it's right. We'll make sure that your rights are protected. Now, when you're on a medical leave, if the company is restructuring, and as a result of that restructuring, you lose your job, potentially that's legal if it has nothing to do with your medical condition. In other words, if you would have lost your job, whether you were on a medical leave or not, then it's legal, and now it becomes a matter of severance. Where it becomes illegal is if they let you go because you're on a medical leave. can't do that. Absolutely. That would be a human rights violation, potentially an employment standards violation. It would be illegal. But if the restructuring happens and has nothing at all to do with your medical leave and you're losing your job unrelated to your medical leave, it's just a matter of severance. But I can tell you there's a 90% chance that the severance that they're going to offer you is less than what you're owed, because that's what happens in 90% of the cases. So as soon as you lose your job, contact me. We'll look at it together. But in the meantime, if you want to know how much severance you're owed, just use the severance calculator, right? Just go to pocketemploymentlawyer.ca and click on the severance calculator. Easy. But as soon as you lose your job, as soon as you have that piece of paper, connect with me. Employmentlawyer.ca to connect with me. I'll help you for sure. All right. Let's see. Questions. Next question is from from Candace. I think it's Candace. My husband returned to work after being on disability, and he has been demoted. We need to know next steps. Does he refuse the job offer or resign? Neither. He calls me. He does nothing until he calls me. Okay. I want to understand why the job changed. Did it have anything to do with his medical leave? I want to understand the demotion. Does it mean that he was a manager, he's no longer a manager? Does it impact his pay? I want to understand how different the old job is from the new job. So I need to have questions or answers to all these questions. It's quite possible that this could be a constructive dismissal. Okay, quite possible. It could also be potentially a human rights violation. So this is too important to just try to make up an answer. I want you to connect with me, or you have your husband connect with me as soon as possible, right away, today even. And let me get some answers to some questions from him, and I'll tell him exactly what his rights are, what he can and cannot do. He should not do anything, nothing, until he speaks to me, okay? So Candace, he can connect with me now through employmentlawyer.ca. Again, employmentlawyer.ca. So you say that you called, and you left a message. So we return calls within 24 hours. So if you left a message January 26th, we would have called back within 24 hours. Check your phone. Call us back again, but we always call back within 24 hours. Okay, Candace, again, employmentlawyer.ca. All the contact information is right there. All right, let's see. See if we can get one or two more questions. By the way, I'm Lior Samfiru, the employment lawyer. Goldman 4856. I'm likely to be awarded 10 months of back pay as well as reinstatement by the Ministry of Labor for a reprisal termination. Can my ex-employer maliciously delay both these remedies by appealing to the OLRB? Absolutely they can, yes. But if they want to appeal, they have to pay the money into the OLRB. So let's say they owe you $50,000. I made up a number. They have to pay that money to the OLRB in order to have the right to appeal, but they do have a right to appeal. But if you're doing this on your own, you're at a disadvantage. Let's talk. If I'm acting for you, or my team is acting for you, we may be able to get this resolved to avoid the appeal and potentially on better terms, okay? So again, you can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. I see a question here from Josie. Do you offer services in French? We do have French-speaking lawyers, so yes, you can connect with me, and I'll connect you with one of my colleagues to connect with me. Again, employmentlawyer.ca. So, Candace, to connect with me, you ask, again, employmentlawyer.ca, phone numbers there, email address is there. But I assure you, if you left us a message with your contact information, we call back within 24 hours. So you would have received the contact from us within 24 hours. Some people, we leave voicemails. I don't check their voicemail, and they think we didn't call them back. We always do. Guys, this is the time I have for today. Thank you so much for being here. Lots of questions today. I asked you to keep me busy, and you did. Really appreciate that. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And now that this session is over, I'm going to encourage you once more to connect with me and my team by phone, by email, all that contact information right here, employmentlawyer.ca. All that you need is right there. I'll be back. My team will be back here as well. Sounded like Arnold Schwarzenegger there. Doesn't matter. But don't wait for us to be back. You can connect with us today, right away. Again, employmentlawyer.ca. Thank you, everyone, for being here today. Always a privilege. Great to be here. And we'll talk to you again very soon. Take care.